talking just briefly about the submissions, and you've probably heard some of this already this morning, so we're zooming by it. I loved what Shauna said about organization, because I think that's one of the only ways that you can be really successful in these kinds of cases. Because as she was talking to you about, there are so many pieces of evidence, and there are so many things going on, and you're typically dealing with an unsophisticated client. So as you're putting together your submission, which you have to do prior to trial, and there's all sorts of rules about the timing of that, think about what your evidence is and organize it as well as you can. Think about, it's one of the things that I always trained my subordinates on. When you're going through your file, when you're going through your evidence, when you're interviewing your client, you have to already be thinking about how you're presenting your case, because that's how you fit the building blocks into what becomes this beautiful Lego creation, right? So think about that as you're putting together your submission, and hopefully that's useful to you once you get to the court. If you haven't talked about this so far in any kind of detail, just remember, if you have a page number on everything, it will be your saving grace. Because when you walk into immigration court, unlike for those of you who are litigators, unlike a court where you get an exhibit sticker and you know you're talking about exhibit A or you're talking about exhibit 2, there are no such things, at least in my very limited experience in immigration court. And so you have to be referring to your evidence by way of page number or page numbers. And you want to be doing that because everything is being tape recorded. And talking about a piece of evidence, pulling something out of your materials to hand to a witness, the record, that's the tape recording, doesn't know what that is unless you're describing it. And the best, most infallible way to describe it is by page numbers, because that's what your submission had on it, and that's what will go up on appeal if you're unsuccessful. So remember to do that. Don't make the mistake that I made, which was putting everything in a 3-ring binder because I thought the judge would appreciate it, and it was all like pretty and stuff, and then I got hollered at because, of course, it's not supposed to be in a 3-ring binder. It's supposed to be handled in a very different way, and you need to respect those rules. A couple things about before you get into court. Sophie told me this when I took this, my first case, which was, have this pre-conference call with the government attorney. Most of our government attorneys here in Buffalo are, reasonably helpful. They're going to advocate their position. It's not like we're going to convince them to, lay down and let us trample all over them, but they're going to be pretty transparent. At least that was my experience with one of the toughest government attorneys here locally. She was very clear about what her position was. We were willing to have a dialogue about our case. She was willing to have a dialogue about her case, and it helped set that stage for the next week or 2 weeks from then, when I was going to be walking into court with clients who were very, very nervous. You've probably talked a little bit about pretrial motions this morning. Understand that you may not get decisions on the pretrial motions before you walk into court. So, for example, I made a pretrial motion asking the judge here in Buffalo to allow 2 experts, I had 3, I was so fortunate, 2 experts who were out-of-town academics to testify by telephone. They were willing to do it. We had kind of set up like an hour period of time. My hearing, I actually had a 2-day hearing. My hearing was in the afternoon. They were professors who taught classes. And so I made the motions to the judge asking that these 2 professors be entitled to testify by phone. And I had no idea whether he was going to allow them. And they were incredibly gracious. I'm sure not everyone would be under those circumstances. But I literally had a paralegal with me as I walked into court, and the first thing I knew on my docket was, did you grant my motions or not, Judge? And so that she could run out in the hallway and at least afford them the courtesy of saying, we are going to be calling you or we're not going to be calling you. That didn't work out because the judge wouldn't tell me. So, but that's, we're going to get to that point in a second. Third parties' attendance in the courtroom. So you've talked about how important it is to have witnesses, to have supporters there. You also have to think about asking the court for that permission, getting the consent of your adversary in advance to have people in the courtroom. Unlike you go into state Supreme Court, you appear before Justice Curran or Justice Walker, anybody can sit there. High school kids tromp in and they, observe what's going on. It's not the case necessarily for these sorts of hearings in immigration court. And so this all has to be vetted in advance and agreements reached. So again, keep that in mind. And then interpreters, that's another focus of a pretrial motion, and I'm going to talk about interpreters in the preparation stage as well. But that's something you have to think about, and that's really a judgment call on your part. So say you have a client for whom English is not her first language. You have to meet with that client a couple times and get a sense. Can she understand well enough English? Do you want it to be sort of the smooth process of question, answer, question, answer? You've got that relationship, but you always have to think, too, there's going to be an adversary attorney questioning. And at least in the Buffalo court, there's probably going to be a judge questioning. Do you think your client is going to be able to follow her second language throughout the pressure of that situation? And if your answer is no, either because your client's English isn't smooth and sophisticated English, or because you think in the heat and the pressure of the moment, the client may need to resort to her native language, the language of her home country, you have to arrange, you have to make that motion to ensure there's an interpreter of that language available. My case was with a family where the husband and the wife had been born in a country called Eritrea on the eastern coast of Africa. I had frankly never heard of the country Eritrea, certainly had never heard of the language, which is called Tigrinya, and didn't really know how to go about finding an interpreter. Sophie, of course, was really helpful in kind of pointing out, this is what you need to do. Pretty typical to have some obscure either languages or dialects in immigration court, and the court's personnel is prepared to identify and find those interpreters for you. The wrinkle is, in some cases, as it was in my situation, the interpreter appears by telephone because we don't have a lot of certified Tigrinya speakers here in Buffalo. So they grab somebody from Manhattan and they patch in by phone. You talked a little bit about preparation of the parties. I want to go there in some depth because for me, that was a critical part of my case's success, and I'm grateful to say I was successful at the trial level, despite some pretty significant obstacles. I'm going to jump down to the very last point I made on my slide, which is having a script will not help you. Do not script out your direct examinations. You need to be working with your client. Needed to have been working with both my clients, husband and wife, on numerous occasions, going through questions in a little different way, in a slightly different way every time. The litigators in the room understand this because we know we have to roll with the punches. We know that when we're in the middle of a direct examination, if we're scripted out, we are going to be required to go off script. And if we're not comfortable enough going off script and coming back to where we need to be, it can be pretty awkward. I don't say that to discourage those of you who aren't litigators. You can do this too. There's not like some magic litigator gene, I promise you. It's really about that organization and getting comfortable with the notion of role-playing with your clients, going through the facts, going through their background, trying to bring them around to understanding that we ask questions and we expect answers as succinctly and as clearly as they can possibly give them to us. I put up there, the challenge of dates and times, and that really is a cultural issue, I found. In my client's culture, they had no need, focus, or desire to remember their dates of birth. It's just not done culturally. So for both of my adult clients, and I had two minor clients as well, derivative clients, their birthday was the first day of the month in which they were born. You know, which puzzled me at first. How can this be? What are the odds of that? And then I realized, you know, nobody writes that stuff down in Eritrea. They just don't. And so that's like a sort of a goofy example, but a more important and more substantive concern is if there are facts that drive your case about, in my case, when torture occurred in the home country. If you have a client who, just because culturally they don't focus on that, you may have a client saying one thing in an application in writing that was prepared well before you were involved in the case, and another thing to you, and then another thing perhaps when you get to court because of the nerves that come into play at that point in time. And so dates and times and circumstances, who was there, what were they doing, remember as best you can. I'm always real careful to say to clients, I am not here to put words in your mouth. I'm going to suggest some things to you just to try to trigger your memory around some things that have happened in your life or some circumstances that are critical for us to get out, to explain to the judge. But just because I say, did that happen during harvest time? Did that happen when you were moving the goats from the south of the country to the north of the country? Doesn't mean that's when I think it happened. I'm just trying to put it in some context for you. Depending on who your clients are, you may need to ask questions like that. You may need to probe. And importantly, you may need to step back and just take a few moments to explain to your clients, this is why it's important. These cases almost invariably rise and fall on credibility, on whether that one individual sitting there in the room believes you're telling the truth. And if we can present our story, our situation, our circumstances in a way that's truthful and consistent, we are increasing our odds of that judge believing you. It's as simple as that, but that's a concept that's foreign to some people. And so it makes a difference to spend a little bit of extra time to explain that, and maybe revisit it a couple times to make sure your clients understand it. The awkwardness of the interpreter, I alluded to that because sometimes we have interpreters that are there by phone. It's really this very awkward multi-step process. Tell me your name, please. From the telephone squawk box comes, tell me your name in Tigrinya. Then the client answers her name in Tigrinya. And then the squawk box says it in English. And God forbid your client answers your question because she kind of knows English, right? Then the wrath of the court, in some circumstances, may come down on your client and you because the client needed the interpreter. And so the client must use, for record purposes, the interpreter to answer every single question. I put this in this section because it's something you need to warn your client about. Even though we've become close, even though, you know, we kind of talk in ways that we understand each other for the most part, we're going to have this interpreter. And so when I ask that question, and of course I'm looking at you, please remember you've got to just pause. You need to hear it in your native language, and then you need to answer in your native language. So it's just one of those little bits of awkwardness that if you prepare for it, it will go very smoothly. So dress and demeanor is it's important wherever you try a case, right? You want a client to come in looking respectful and not like, you know, you've dragged them off the street corner. Our clients sometimes don't have the benefits of having the kinds of closets, you know, you and I might have. And so it's important to talk about that in advance, again, in a non-threatening way. All of this is so, I mean, what made it so fascinating is there was this rich culture of my clients and a very foreign attorney I knew nothing about them. And so it took some doing to learn about how they dress, what their demeanor is like. I found, for example, my male client never looked up when I was asking him questions, because I found that in his culture, it was an act of respect to not stare at me in the eyes, to not make eye contact. That's very common around the world in places other than the US. And so you've got to drill down to that, and you have to role play with your client by explaining that, actually, sir or ma'am, it's important to look me in the eyes and to look the judge in the eyes, because we, in our culture, read that as a sign of credibility, of certainty, of not trying to evade or avoid the question. So those are the kinds of cultural differences that we face with some clients. Practicalities of trial, and here I'm going to talk about the Buffalo courthouse, because I haven't had the honor of being in Batavia yet. So the Buffalo courthouse has, of course, enhanced security like any courthouse around the country does. It's a very small waiting area. You heard me say I had two children, two young girls for my clients, and my adult clients had had a third child here in the States. So, and as the case with many of our clients, they don't have extended family, they don't have a lot of support in our community. My clients needed to bring their children with them. We arranged it so that they had a family friend, someone they had met here in Buffalo since coming here, come with them to be with the children in the waiting area. You know, we talked about having things like coloring books and small toys that didn't make any noise with them to keep the kids occupied. And we also made arrangements. I was fortunate at the time I had an office that was just across the square from the courthouse, and I made arrangements to have a secretary available in one of our small conference rooms, that if the kids really were kids, right? There was this 2-year-old and a 3-year-old there at the time, that they could walk across the street and just hang out there, and you know. So those are the kinds of things you have to think about children-wise. And the courtroom here in Buffalo isn't, you know, you walk into federal court, you walk even into state Supreme Court or city court, pretty big courtrooms. Over in immigration court, pretty small courtroom. So I was at my desk, and the government's desk was, you know, probably about this distance. Maybe I could fit my hips through. Maybe I couldn't, actually. We were really close to each other. The judge was really close to us. There wasn't a lot of personal space for me to turn to my client and have a quiet conversation if I needed to during part of the proceedings. So just keep in mind that you're in close quarters if you end up here in Buffalo, and it makes some sense. Often we get these cases after the preliminary appearance has already been taken care of by Bob or someone else at VLP. It makes some good sense to try to visit that courtroom if you can, just to get the lay of the land. So here's my runner, because what I found out, you know, and I had a case that I had prepared as diligently as I could. I had what I thought was a meritorious position, a woman who had undergone torture in her home country, and I had a lot of evidence. Of course, I had a 3-ring binder, which I wasn't supposed to have, but I had a lot of evidence. I had a big litigation bag, and we're out in the waiting area, and our conference hearing was in the afternoon, so we were kind of gently waiting for the judge to get back from lunch, and we saw him walk through, and in a couple of minutes, the door opened. We were escorted into the courtroom. We were invited into the courtroom. And I will tell you, I had not even gotten to the rail. You know how there's usually a rail? You've got to push the little rail open to get to your table. I was not at the rail yet when the judge asked me to start my case. It's just kind of a personality thing. And so what I learned in that moment that helped me on the second day of my hearing is that I couldn't walk in there, as I do in most courtrooms, with my litigation bag and sit down at my seat, pour myself a glass of water in case I get dry mouth, and take out my materials and be ready to go. I had to walk in there, dragging my litigation bag, but with my materials in my left hand, ready to freaking go by the time I got, halfway into the room. And you just, to know that empowers you, right? Hopefully you're not the dork I was the first day I walked into that courtroom, where I had to sort of, pull things up and get myself sort of centered in order to answer the judge's inquiry. Are you ready to proceed, counselor? You may begin. So I say that, it threw me off my game for about a half a second. I'm fortunate that, in a couple of decades of trying cases, I can kind of go with the flow. But for those of you who don't try cases, use this to empower yourself. Know the first words you're going to say before you walk through that door, so that if you get the same snarky post-lunch judge I happen to get that day, you're ready to go. Okay? So be prepared before you enter. You have the right to waive a preliminary statement. You don't have to do that. I think it's a good idea to make a preliminary statement, an opening statement in a sort of a more traditional courtroom. Gives you the opportunity to kind of set out what you're going to present to the court. It also gives you an opportunity. Think about your clients here. It gives you an opportunity to settle your client, particularly if your client's going to be your first witness. So what I said, at least in the Buffalo courtroom, you might walk in, be asked to go like that. Your client, has been maybe in that courtroom one time before. It's high stress. It's high drama. Making an opening statement in a very deliberate way gives your client a chance to take a few breaths. Gives your client a chance to sit there, and he or she is not going to be any less nervous. We really can't remove the nerves, but that will give your client more confidence, and he or she will see you are in command of their case. And I think from a psychic level, just from an emotional level, that's a really important moment of pause. Not for you, put some pressure on you. You got to deliver an opening. Think about 5 minutes max. It's not some long, 35-minute oration to the court. But it gives your client a chance to sit there and to feel like I'm in good hands. I'm in hands that are going to, make this successful. I want to talk about witnesses for a couple of minutes because, of course, your client is a witness. You may have other witnesses. This is typical courtroom practice. And so for those of you who are litigators, I apologize. I'm going to talk about it in terms of when you've never tried a case, when you've never walked into a courtroom. So you're going to see that it's the judge himself who swears the witness, at least in Buffalo. So a good piece of advice, show your client how it's done in advance. They're going to ask you to raise your right hand. This is your right. It's the, whatever you do, ever since elementary school, to me, it's the one I put on my heart. Okay, so they're going to ask you to raise your right hand, and they're going to say particular words. Do you swear to tell the truth? Do you swear or affirm to tell the truth? Go through that so they understand all that is doing is confirming for the judge they're there to be truthful. So it's not, some great, magic that's going on. It's really just sort of a tradition, a ritual we do in our country to ensure truth-telling. It's not their fault, and it's our responsibility. And in some ways, kind of it's our joy to be able to relay that, ritual, the importance in our set of justice to what that means, and then to demystify it. You're not doing something that will hurt you, and explaining to them why telling the truth is so important, and how our justice, and that goes right back in the big circle to credibility, which I talked to my clients about a lot in preparation. What credibility is. I used that word. I explained it in as simple terms and in as different kinds of terms as I could, because they needed to understand that even though they weren't inclined to not tell the truth, my clients were incredibly honorable people. And hopefully your clients, even if they have some scars in their past, will approach this process honorably as well. They needed to understand why that was important in our system of justice, when it might not be as important, again, details, not truth-telling, but in their culture, details might not be important. In our culture, it means you're telling the truth or not telling the truth.
They don't do that.
They don't use a Bible. The question was, is using a Bible a problem? They don't have that. So, typically you will conduct a direct examination of your witnesses first, where they're your clients or witnesses you've been close enough to prepare. It makes great sense to have gone through that a few times, as I told you in preparation. It also makes sense to prepare them for interruptions, because interruptions may occur simply by objections from the government, or in some cases the judge interfering and asking questions that he or she, depending on where you might be in this great country of ours, needs some more clarification on. So I say the court's role here because what you may find if you're in the Buffalo courthouse is that the judge will or may try to ask quite a number of questions designed to probe credibility of your clients. And that may very well take place during direct examination. So one of the reasons I started out my remarks by saying a script isn't useful, because I think you need to prepare yourself for those interjections. They may not happen, but like in my case, they may happen and they may be quite frequent. And so the client needs to understand that the judge, so this imposing person in a robe, isn't asking questions because they've done something wrong or they haven't answered correctly. The judge is simply trying to understand, even if he appears as though he's angry, even if he appears as though he's being repetitive, he's simply trying to understand. And I think it's really important to assure our clients that if they have given an answer and they know it is the truthful answer, just like in cross-examination in a traditional court, cross-examination sometimes can be designed to try to get that client, or your witness, to change his story. And it's human nature, truly it's human nature, particularly with people who are unsophisticated. If they're probed and probed and probed with the same or similar question again and again and again, they start to doubt themselves. It's human nature. Oh, maybe I didn't get that one right, and I should change it. So that's another preparation tool or strategy. If your client is very firm on this fact, I left my country via the mountains on January 14th, 2009, even if they're questioned again and again and again, was it really January? Wasn't it December? Wasn't it before the new moon? Wasn't it after the full moon? If they know when that was, whatever that is, they need to understand that even if they're questioned again and again and again, they need to stick to what they believe is the truth. And you can bring that back full circle to this issue of credibility and truth-telling. And I think it's also really important to explain to our clients that even if the judge or even if the government attorney looks angry, looks mad, is being insistent, it is not about you. It is not about you, client. So while we want you to be attentive to them, we want you to make eye contact with them, we want you to be firm in your answers, but we also want you to be polite. We don't want you to internalize what might appear to be anger or frustration or aggressiveness. Simply try to listen to what that question was, take all the inflection out of it, and answer it as best you can. I told you a moment ago I was lucky to have two experts who were at a distance and who submitted affidavits for me. I also was lucky to have a medical doctor here in Buffalo who agreed to examine my client who had been tortured in an effort to give her medical opinion about the condition of my client's body that demonstrated objectively that she had undergone this torture. So sometimes we're not lucky enough, sometimes we don't need experts. But if you think your case would be enhanced by an expert, by all means, talk to Sophie, talk to Bob. There are people, there are amazing angel-type people who are willing to do this pro bono, pull away from their medical practice or their psychiatric practice, and work with you and with your client. I think experts can be an opportunity for a credibility swing, because when credibility is kind of the fulcrum on which many of these cases are decided, having an objective individual, or as objective as an expert can be, of course you want to, in your direct examination of the expert, bring out immediately that expert wasn't paid. Not one of those situations where they're making 20 grand for 15 minutes of testimony. The expert wasn't paid. Another really useful question I found, and it only applies when the circumstances merit it. So I had a situation with a client who had a physical deformity because of the torture. And so this expert, this medical doctor, talked about the examination of my client, also talked about her interview, history and that with my client. And the judge questioned the expert pretty strongly on how much the expert relied on my client's history, right? Going for credibility. So if the party isn't telling the truth, doctor, then maybe your opinion is flawed because you weren't given accurate information from that patient of yours you were examining. Well, here's the question that can work to really support your case if it applies, and that is, doctor, if you had never spoken to my client and just had done your examination, would your opinion be the same, or would it be different? And if there is physical evidence that in the doctor's opinion can only occur because of torture, or is most likely to occur because of torture, that answer to the question, in my mind, removes all of the credibility concerns that might come from taking a history from a less than accurate or credible individual, right? So think about that as a possibility if you're going to have an expert in a situation similar to the one I just described. Also, I think even if the expert has appeared before that particular immigration judge before, and we do have professionals in this town who will do this for VLP again and again, I think it's important to go through that professional's CV, their resume, and talk about, have the expert, of course you're not leading, you're asking open-ended questions in direct examination, have that expert go through all of his or her background. Again, that enhances credibility. Whether it matters to the trial judge you're in front of is almost of no consequence, particularly if he has heard this expert before. But what you're doing is you're driving that information into your record for appeal purposes. So evidence is kind of loosey-goosey in immigration court. And I will say this, the most important strategy I think that you need to employ for evidentiary purposes is knowing how to set a foundation. So there may be lots of documents that you want to have in evidence. They were part of your submission. They may be letters, they may be country reports, they may be all sorts of things. That applies, of course, in an asylum case like I had. But there may be other documents. Shauna talked about a number of documents that she might be submitting in her case. To set the foundation, even if the client can't answer all these questions, or even if the expert can't answer all these questions, it helps to enhance the credibility of the documents and make it more likely either that the judge accepts them into evidence, or if he doesn't, that the appeals, the BIA, will find that he made a mistake in not accepting them into evidence. And foundation is really just that old newspaper reporter question. Who, what, when, where, and why/how. How do you know that's true? If you ask those questions, I, for example, had some letters from my client's parents back in Eritrea where they talked about another basis of my client's request for relief was religious persecution. And they talked about the climate for the religion of my clients back in the home country. Well, it was a letter, it was in Tigrinya. It had been, and they need to be translated into English, but we had asked my client's parents to make sure they included some sort of photo ID, photocopy of their, the ID they use in Eritrea, and they did. And so I was able to ask my client, both my husband and wife, because both had relatives who wrote on their behalf, look at this picture. Is that your father? Yes, it is. How do you know that? Well, it says, it says his name, but I also recognize his face, even though it's blurry and black and white. That's my father. And then I was able to ask, look at the signature on the page. I know that signature's not in English. Can you read it? Yes, I can. Whose signature is it? It's my father's. Well, how do you know that? Well, I saw my father write his name, or my husband client. I saw my sister write her name for many years when I lived back in my country of birth. I recognize it. I know that that is her. I know that's her handwriting. And again, that helps you when you go to proffer that evidence. Your Honor, I move to admit pages 42 through 48 in evidence. It gives you that foundation. It's very useful. Let's see. A pop-up happened. Let's try to get rid of that. Let's see if this works. Okay. So I talked about this, foreign documents. That's sort of what I was just describing. So I have a few more minutes left, and I want to talk specifically about the court here in Buffalo. And I want to talk about that because the court here in Buffalo is not an easy court to appear before. I told you that I had been trying cases for 23, 24, 25 years at the time I went to immigration court. And this is how I felt. I was banging my head against some bricks. And I'm trying to be very respectful in saying that. We all feel that sometimes as attorneys. Sometimes we feel like we're banging our head against the wall because of the client we're talking to, because of the adversary we're dealing with, because of our partners or colleagues or our secretaries. Sometimes it's the cash register lady at WEGS. We're human, right? But in a courtroom, it's incredibly important that we learn to deal with what is perhaps impolite conduct in normal society. And by that I say, things may happen if you're trying your case in the Buffalo courtroom that you wouldn't expect to happen. I think that's what makes it fun and a challenge, frankly. Because we deal with all sorts of people, right? I just said that. Appearing before Judge Arcara in federal court is really very different than appearing before Magistrate Judge Schrader in federal court. We learn to deal with different personalities. What's unique about us, right, is this is probably the first time we're going to be dealing with this particular judge. Or if you're in Batavia, with that particular judge. And while the demeanor and the conduct of judges in different places might be different, the underlying lesson is this. We got to be ready for whatever comes our way. And we have to know that it's not about us. As much as it might appear to be about us, as much as it might be offensive questions to somebody who's litigated for 20 years about, the way you stand in a courtroom, it wasn't about me. It wasn't about me at all. And so it wasn't necessary for me to outwardly show maybe the frustration, perhaps even the disgust I felt at being treated the way I was being treated. That happens everywhere in courtrooms across our country. And it may happen in a courtroom here in Buffalo if you have an immigration hearing. Don't let that scare you. Don't let it intimidate you. You are there to do a job for somebody that you have determined is deserving, that Bob and Sophie and a slew of their staff members have determined is entitled to your good and competent representation. And the fact that a judge, wherever you are, might feel like you're imposing on him or her, might feel like you're not doing it precisely right the way it's done in immigration court, doesn't matter in the big picture. You're there to put on a case, and you're there to do it in a respectful way despite what might be interruptions and other sorts of things that are exhibited to you by the bench. And I want to talk about emotions, and Shauna did a great job talking about the tears. I want to talk about our emotions. Because sometimes, wherever we are, we've got a pretty tough row to hoe there. We've got a tough path. It's, you know, I can go uphill battle. It's tough. It's hard work we're doing. But remember that old adage, never let them see you sweat? I think that's particularly relevant in circumstances where we feel unnerved, not only because maybe we're presenting a case to somebody who appears to be trying to undermine us, but also because we're new at doing this, because we haven't handled this case. And I think it is acute human nature to feel like, in those circumstances, I am doing this wrong. And I am here to tell you, you will not be doing it wrong if you've prepared the way you would prepare for any other client in your particular area of practice. Because you will have had the great support of the VLP folks, you will have had all the education you got here today, you will have accessible to you those of us who have gone before you, and there are any number of us who are willing to take phone calls, to chat over a cup of coffee as you're preparing, to help you get through this process. I had it done for me. I have in turn tried to do it for those who have had cases since I had mine. We're kind of this little, small, kind of really, I think, profound group of individuals. And I don't say that to sound arrogant. It sounds a tiny little bit arrogant. I don't mean it that way. What I mean is we have done something or are doing something that very few people, at least in this community, are willing to do. And we are doing it in circumstances where we may not have the model client. You know, it's one thing to go in there with like the priest, minister, and rabbi as your client. That's easy, right? We may be going in there with somebody who has a felony conviction. Or we may be going in there with somebody who can't speak this language and doesn't understand why she's being put through this. She just wanted to find a place that was safe and where her daughters wouldn't have to undergo the mutilation of their genitals the way she did. That's like the human condition about this. And that's why what you are going to be doing is so critically important, and why I want you to hopefully remember these words if you're feeling berated by a judge when you get before him or her on one of these cases. Stay the course. Put on your case. Put in the evidence. Do the best you can do. That's really all there is to it. Even if you feel like, oh my goodness, he's yelling at me again. It's all about him. It's not about you. Okay? So, the record. You've heard it this morning already. I'm going to say it again. As attorneys who are putting on cases, we have to have this dual track. It's not a complicated dual track. You're putting in your evidence. That's your primary goal because you want to win it there, even if it takes 6 months to get a decision. You want to win it there. But in the back of your mind, you have to remember, I might not win this, and so I have to make sure everything that's being tape recorded is clear to those who will be assessing whether I should have won when the case is up on appeal. And so that's why You have to have this solid record. That's why when you refer to documents, you say, I'm talking about page 2, Your Honor. Well, I know what you're talking about, Counselor. I understand that, Judge. I'm just trying to protect my record. I'm just trying to make my record. I am simply putting this on the record. That all can be said without sarcasm, just as a matter of course, because that's what we do when we put on a case. We make sure we have a record. And so, when I say the final proffer, what you might find if you have a fair amount of documentary pieces of paper or things, evidence like I had, is you might ask your clients about it or a witness about it during the course of the hearing. You might proffer or offer that evidence at that time, and you might hear the judge say he reserves. He reserves. So he's not going to decide then, he's going to decide later. That's okay, he's wearing the robe, they're allowed to reserve on things. So when you get to the end of your case, the end of your proof, if the government has witnesses, in my case, the government didn't, the government actually consented to the relief I asked for and advised the judge of that, and he still made us try our case for 2 days, even though the government consented to the relief. But when you get to the end of your hearing, you have to make sure all of your evidence is in the record. The testimony is in the record, it's been tape recorded. If you have documents that you're not sure the judge has ruled on, or you just, you had them in there, UN country reports about torture that occurs. You want to make sure you get everything into the record. And so that's that final thing you do, and that is, Your Honor, I offer pages 1 through 562 into the record. And then you expect the judge to give you a ruling. And don't be surprised if the judge reserves. And sometimes you might need to say, well, Judge, the way I know how I'm going to close, make my final remarks or my summation, the way I know what to talk about is what's in evidence. Because in a traditional courtroom, you can't talk in a closing about anything that hasn't been entered into the record as evidence. Well, sometimes in immigration court, you may have a judge who refuses to rule. And don't let that throw you off your game. You have a job to do, you're in there. The fact that that judge may not rule is not a reflection of you, or that your offer was flawed, or that you didn't do it right. It simply may be heartburn. And so what you do is you don't fight with the judge. You ask the judge a second time, Your Honor, for my record, I ask that the court make a ruling on whether my evidence is in or not in the record. And if the judge still won't make a ruling, and if the judge yells at you, and if the judge points his finger at you, you simply close on the evidence as if it were in the record. You close on the important testimony, you close on the important documents, and you make the presumption, I know we don't usually do that as lawyers, but this is a different place. You close as if that material is in your record. And so if there's a really important document, let's say it was the father's letter that talked about religious persecution, I will talk about that in my short summation. I'll talk about what was the important evidence. I'll talk about what shows my clients not only meet the test, but have credibly relayed the facts that should compel that judge to decide in their favor, whether he's ruled on it as being in evidence or not. Because that's what we do to protect our clients. And there's really no magic to summations. We've seen them on TV and in movies, and people talk about them in law schools. It's really about marshaling or summarizing the evidence, especially when you're talking to a bench, a judge. It might be a little different before a jury, but it's about talking about the highlights, the standard, and why the judge should rule respectfully in your favor. And so here are the two couple concepts I want to leave you with. I want you to remain poised. It's awfully important, and it's a little bit of a challenge in some of these courtrooms if you haven't gotten my drift so far. And I also want you to be tenacious. I want you to keep at it. I want you to, even when you feel like you've got the orange vest on and you're slogging down the road, breaking up the asphalt with a hammer, I want you to keep at it. Even when you feel the sweat trickling down your back, keep at it. Be poised and keep at it.